is now in session.
All right, good morning. Please be seated. We're here this morning for oral argument in case number CV230805 FC, Douros versus Morse. Each side will have 20 minutes to argue. Appellant's counsel, if you'd like to reserve any of your time, that's up to you. The proceedings are being video and audio recorded this morning, so when you approach the podium, be helpful if you identify yourself and who your client is. We've read the briefs, conferenced the case, and reviewed the record, so please keep that in mind as you make your arguments. And with that, we'll get started.
Thank you, Your Honors. My name is Justin Heap. I represent the appellant Brittany Lee Morris. The case here in Arizona law recognizes that grandparents have a right to petition the court in order to receive reasonable visitation. However, both in statute and in case law, that right is somewhat limited and is subordinate to the wishes of the parent. This is general, and in this case, we have a case in which we have a parent a minor child who is now 11 years old. At the age of 3, the biological father was killed in a car accident with the child in the car, and following that time, with no orders.
Counsel, I'll just have you jump ahead because we are familiar with the facts.
Sure. Okay.
A question for you, just to clarify. I understand that your challenge is an as-applied challenge. That
it is an as-applied challenge.
As a matter of constitutional law,
that's correct.
The court's award of visitation time here violates your client's parental rights.
Right, Judge, and that is based on the court's finding following rulings in Truxell and McGovern v. McGovern that says that the court needs to give special weight to a fit parent and not inhibit the constitutional rights of a parent to make decisions for the minor child. In this case, we're not contesting that the grandmother does not have grounds, and it might not have reasonable grounds to receive that. However, the court's basis for issuing that and the amount of the award we believe is excessive, and that this places an undue burden on mother to comply with this order. What essentially?
What does special weight mean? The talker has to give special weight to the parents' opinion or wishes. What does that mean? How will we know when the court has given special weight?
In the present case, the changes in the relationship between the parties has changed substantially. Though mother did voluntarily allow visitation, mother made it clear both in her testimony and in evidence presented to the court that mother and grandmother's relationship has been deteriorating steadily for the last 2 years, even leading to physical altercations between the parties. This it's clear that mother has made it clear that she no longer has confidence, and so in this case we have the court essentially asserting grandparents' rights against an unwilling parent who has expressed that she is not willing to or does not wish the grandparents to have visitation. Now, it may be within the court's right to get that. However, as the biological parent, her rights take priority, and the court at least needs to acknowledge that in its ruling and what mother's wishes are, and take that into account. I believe that is what is required under McGovern and the court's ruling in the Borges case earlier this year.
Special weight, it's not a presumption. I mean, Troxel uses that term, and then I think the legislature picked it up from that case, and I'm not sure a lot of meat has been added to that term. So it's unclear to me whether it's a presumption or it's just an evidentiary standard, or it's just something the trial court needs to take into account when making this decision.
Well, whether it is a firm presumption or simply something the trial court has to take into account, it's clear from the ruling that was issued that the court did not take that into account. This case was, we had a very brief hearing that lasted only each party about 45 minutes to present their case. The judge then immediately issued a ruling using standard forms which she hand wrote and described. And in that, she does not address in any sense the wishes of the party or the issues. It does seem as if she created a presumption based on prior activity before this case to place the parties essentially on equal standing.
So special weight, does it come into play just in the best interest determination, as when deciding whether the third party should have any visitation rights? Or does it also come into play in your mind in the determination of what a minimally intrusive amount of time for visitation is?
I would argue that it should come into both. It should at least be addressed by the court. The court found that both mother and grandmother were fit parents, and so the presumption then should be that that constitutionally a parent makes the decision they believe is best for the child, and that the court should defer to that. If the court is going to then reverse on that and grant rights against the issue, we believe they should at least address the mother's wishes and state exactly why those wishes are not there. You then getting to the issue of whether, I'm sorry, excuse me.
The trial court here made the best interests finding. I don't think you're challenging that on appeal. You are challenging the amount of visitation that was awarded. What was your client's express preferences in terms of how much visitation?
Well, my client has stated at trial that she no longer felt that the child was safe in mother's care. Now, the court can disagree with that. But you are correct in that our primary assertion here is that the amount awarded against the wishes of mother is unduly burdensome. It's not minimally, it's not minimally burdensome on mother. In fact, what the court awarded in this case is essentially almost a third of the year to a third party. That is the kind of time we would expect a parent to receive in this case. We don't.
Counsel, what is minimally intrusive? I mean, if we took the word as its literal meaning, 0 is the only acceptable amount. So what more than 0 is still minimally intrusive?
Well, I think minimally intrusive is, I don't know that the court has given any specific guidance. I haven't found a case where they've given specific guide rules on what exactly that term means, but I think it is clear that giving a third of the year to a third party over the wishes of a parent who, whether the court agrees or not, has stated legitimate reasons why she feels that child is, cannot be interpreted as being minimally intrusive. This is...
Counsel, I have 2 questions on this front. I guess as a sort of threshold question, bigger picture, you said has given legitimate reasons. If we have here a fit, there's no argument mother is unfit, legal parent who has expressed an opinion, and that parent has a fundamental right to the care, custody, and control of her child, does she need to have a legitimate reason to prefer her child not go with a third party? Do you think that's something that's written into the statute? And if it is, do you think that intrudes on the parent's constitutional rights?
In some sense, I do. If it's I do as a fit parent, I suppose, even if whatever their reason, whether they simply cannot get along or have any reason, I think that there is an intrusion. However, the legislature has put in place law that states that if it is found to be in the best interest of the party, that can be awarded over the wishes of the parent. The question we're really dealing with here is not the constitutionality and can any parent completely deny over the will of the court. It's where is the line for how much the court can give over the wishes of a parent. And I would argue this is per se. Yeah.
You correctly identified that this court has used this minimally intrusive language without necessarily defining it. You pointed to the nearly 1/3 of the year as a sort of a mathematical amount this year. Let's assume for the moment that you had the opportunity to define minimally intrusive. Do you think that is something that is a matter of math, of amount of time, or what does it mean to be minimally intrusive? And how would we guide a superior court who's looking at this kind of a case on a case-by-case basis to evaluate the evidence and the preferences of the parties as expressed?
Well, in this case, I don't know, whether it can be broken down to a simple calculation of math, except that I think all of the case law that is presented on this issue says that unless the parent is found to be unfit, that the court needs to give special deference. I don't see anything in this record that says that any sort of deference was given to mother. In fact, I think the presumption was shifted to mother to try to prove that somehow grandmother should not continue to have essentially the same amount of time as a parent would receive in this case. So I think there are two fundamental problems. Yes, I am concerned with the amount of time. This is, of course, anecdotal and not necessarily, but this is the most I've ever seen a third party receive outside of a dependency case, with a grandparent petitioning to essentially have unrestricted control of the child for 8 days a month and a full month in the summer. And what this does is it does essentially, I think this creates an incredible burden on mother. Not necessarily in that they do live close, can she get there, but she loses access to her child for a substantial period of the year. The child also has younger siblings who are now also excluded. We are asking the court to look at this. So that I do think there is an issue of just the excessive award here given.
Counsel, if we were to agree with you and send this back, what guidance does the trial court have? You say once it is excessive, it might be, but what lesser amount isn't excessive?
I can't look. Unfortunately, I think because of the nature of our court system, it's going to be a case-by-case issue. So I can't put a specific case. If this was sent back to the trial court, though, I think that it's clear from the evidence that the trial court did not even address the issue of whether this was minimally burdensome. We had a very brief hearing. The court issued its ruling immediately after the hearing in a handwritten form. There's nothing inherently wrong also with the use of handwritten forms, but in this process, to use a handwritten form and to simply fill it out, that simply lists out bullet points that and does not take into account the thing. What I would expect to have is that if the court is going to enter such a dramatic ruling, if the court is going to essentially place the child in the care of and place mother essentially in the same role as a parent, then the court needs to take time to deliberate and explain exactly why that is necessary. I don't think filling out the check boxes on a form or handwriting an answer shows that she did the necessary diligence that would be required to support the ruling that she had.
It sounded to me, and maybe I misunderstood, that your position was that mother's preference was 0 time. Once you have a best interest finding, though, that opens up the ability for the trial court then to award some visitation. We don't have that finding challenged before us, so I think I think grandmother was entitled to something, and the standard of review is abuse of discretion. Do you agree with that?
I do.
Okay. So, I guess, am I correct that your position is that the trial court abused its discretion once it said anything more than 0?
No, not that when it said anything more. I think that a more reasonable or brief period would have been acceptable. We're not necessarily arguing that mother does not have a relationship with the child, that the court couldn't find that there is some interest. Mother had made this decision because of the deterioration, I think, but to simply award parent and not even address mother's specific concerns, not to address that this is incredibly burdensome on mother to lose her child for all of this time, and to not even have addressed that on the record, to explain the reasons, or to explain that the court took into account any sort of deference for mother's wishes, is an abuse of the court's discretion. We have to have some limitations on what the court can award.
If the court did what you argue it didn't do, if it had made the proper findings and still came up with the 1/3 of a year, would there be error?
I do believe that the amount of time is prima facie case to say that this is excessive. I think this much time for a grandparent is excessive. However, had the court shown that they had taken into effect, if they'd taken the matter under review and written a response where they addressed all of these legal concerns, that they show that what burdens had been met and their reason, whether we appealed it or not would be very different. I'm sure my appeal would be very different. In the case we have here, the court had a very brief hearing, about 45 minutes for testimony from the parties, and then issued a ruling, a handwritten ruling from the bench immediately after. I don't think that it addressed the requirements to show that the court recognized that mother has a primary right to control, and that it took her cases in. It simply moved straight to a best interest analysis without addressing those other points. And I think that set up just procedurally, it set up a fact that the presumption, once you go straight to a best interest analysis without addressing the rights of a parent, that puts mother is an abuse of discretion, because it puts mother essentially to have to rebut the presumption of the other side that it is interesting. Yes, at the time she is asking for that. I wouldn't disagree that the court could find that some visitation is, but the amount awarded and what was done is clearly excessive, and the court did not issue a ruling that expressed why that was not a substantial infringement and how those burdens were met. I'll reserve the rest of my time. Thank you.
Thank you.
Good morning. May it please the court, Michael Ellsworth on behalf of the appellee, the paternal grandmother in this case. Frequently I meet with clients. I go through the process of informing them about the law. And I explain whether right or wrong or a better way is. We have the law in two kind of different forms. We have our statutes, and then we have case law that helps us interpret that. So in meeting with a client, we can look at the case law, we can look at the statutes if we're talking about decision-making authority and parenting time, ARS 25403. If we're talking about grandparents' visitation, we go through and we list those. And then we look at the case law and say, okay, how do we interpret? So I think to come in and say, well, the judge's ruling is deficient because she used a pre-printed form. Really what the judge did here was the judge went through and checked boxes that needed to be checked.
Counsel, I'm not sure that that's a fair characterization of the argument. Your colleague here explicitly said it's not the issue, is not the form. It is the lack of finding on the parents, the fit legal parents' opinion, the special weight given to that opinion. Could you point me to somewhere in the order that we can see that the court took that into account?
I can't specifically point you where the judge says, I took into consideration and put special weights on what mother's wishes and desires are. But I also have to note, ARS 25403 requires the courts to make certain findings.
So I understand that.
Right, we just don't have that in this case.
409, the sort of directly relevant statute says that the court has to give special weight. And of course, that's language that comes to us from the United States Supreme Court in Troxel. We don't have a lot of guidance as to what special weight means. But when two parties come into court and one party is entitled to have special weight given to their position and the outcome of the court is near identical to what the other party requested, don't you think there's maybe at least a question as to whether the court gave special weight to the opposing view?
Well, I think there would be until we actually look at the facts of the case in this matter. I was here about a year and a half ago, and I started with that bad facts make bad law, good facts make good law. This is the type of case, because we do have the opinion that was cited and been referenced to Bora, that in there the court gave direction of what the trial court shouldn't have done. This is a case where this court can look at what the trial court did and say the judge did this right or looked at these factors.
So having authored it, I'm relatively familiar with Borja. One of the concerns that we highlighted there and that I see as present in this case is the minimally intrusive standard, which was previously set out in McGovern. And there is a fairly compelling case to be made that when a superior court is treating a fit legal parent with a fundamental constitutional right to be on effectively equal footing with a third party who has no such constitutional right, that there is perhaps a departure from the legal standard of either special weight to that constitutional rights holding parent and a minimally intrusive burden. So I would like your help in how we get there here. How can we see that the court gave the fit legal parent with a fundamental constitutional right special weight to her opinion when we don't see anything written in the order to that effect, when the order suggests that these are effectively co-equal parents, when that is not the case? Help me out there.
That's a wonderful question. I'm glad to do that. I'm prepared for part of my argument for that. As I think you had asked opposing counsel was, what did mother want here? Well, mother wanted 0. Grandmother wanted to be reinstated back to what she had had for the about 8 years since this child's father had passed away. And that was like 2 extended weekends per month, which would have been about 8 days per month. I think it was Thursday through Sunday type scenario. What the judge did here, though, if we look, the judge gave grandmother Monday after school until Thursday morning before school. And it's also noted in the record that mother works 12-hour shifts those days. So she doesn't get home till 8 p.m. at night. So really, what time does grandma have here? She's got Monday about 4 o'clock or so when school gets out. Child goes to bed about maybe 10, probably a little bit late, but let's say 6 hours. A couple hours the next morning, child goes to school under mother's care. Grandma has no decision-making authority here. If something happens at school, that's on mom. She's getting the call, not grandma. Tuesday, we do the same thing. Another 6 hours, a couple hours in the morning, on Wednesday. Then we get to Thursday morning, he goes to school, and that's the end of grandma's parenting time. If we add that up, grandma gets 24 hours really with this child twice a month.
So do you practice in the family law area?
I do, and
that is not how we calculate parenting time in that area. I'm not sure that it's a fair way to calculate it here.
But Judge, that's calculating child support. When we're calculating child support purposes, yeah, we count 3 hours or 6 hours or who's got custody here in the family law arena and for child support purposes. This isn't about child support. This is about grandma spending some time with her grandson. And so when we want to say, well, the child's getting 1/3 of mom's parenting time, that's just not correct. If we look at the amount of hours and control she has over this child, it is very minimal. And the days, again, we talk about minimally intrusive. The judge really went through and how the judge came to this, but did it on the days that mom is working her 12-hour shifts. And only says, you can have weekends if both of you agree, which really in essence says, you'll only get weekends if mom wants to let you.
Is there another case in Arizona where a superior court has awarded a similar amount of time to a third party? Doesn't have to be a grandparent either, any third party? And this court or the Supreme Court has upheld that?
I'm not aware of any. There probably could be, but I am not aware of that.
What's the upper limit to that? We have one, and I realize you're disputing how the hours are calculated, but it seems to be a lot of time that the grandparent has with their child and the parent does not. What are the limits to that? Could it be half a year or
Well,
more than that? What is the limit for it to be too intrusive?
That's the vagueness of that term. What is minimally intrusive? But that's why I mentioned earlier, this is a case where this court could come and say, the trial judge here, instead of giving weekends when mom's off work, gave grandma weekdays when mom's working 12-hour shifts. In this case, different than Bora, the only really holiday that that grandma gets here is Father's Day weekend. The judge's order regarding Thanksgiving and Christmas is that grandma will have time near that. And that was an issue in Bora where the court said, look, grandparents shouldn't have 5 or 6 hours, I can't remember what it was, on those specific holidays. And the grandparents in that case got to dictate what those hours were. That is not the case here. In this case, mom dictates to grandma when she gets to see that child, whether it's before Thanksgiving or after Thanksgiving, whether it's before Christmas or after Christmas. So the least intrusive is we're giving mom the opportunity to determine what is most least intrusive to her in this situation. And so clearly the trial court, I think, did a really good job of probably taking Bora and saying, okay, I can't order this because it's already determined that this would be intrusive, so I'm going to leave it vague or I'm going to order something else.
Does special weight go to best interests or minimally intrusive or both?
I believe special weight would probably go to minimally intrusive because once the court finds that it's in the best interest of the child, then I believe the minimally intrusive would be that weight of saying, okay, mom in this case doesn't want any, grandma, she wants her back 2 weekends, those type of things. How do I balance that taking into mom's consideration? And so if we really look at the facts in the court's order, I believe the judge, and going back to ARS 25403, there's not a requirement here for the judge to make those findings. That's a little bit different. But I think if you look at the ruling, it can really be interpreted that the judge did look at that because of how she drafted this order and gave really mom the authority to determine when grandma's going to see her at these other times, and then grandma only has time during these specific times when mom is at work. If we were looking at a parenting schedule, wouldn't we want to maximize parents' time off from work usually and try to balance that? If you've got a parent that maybe their shifts are different, we would try to balance that time, and it kind of looks like the judge did that here.
Well, the language that you're using concerns me. You think about balancing as if they're equal, but they're not equal. You know, the parent, I believe, has paramount rights, and the statute gives a third party some rights, but it has to be subordinate to the parent's right. So when you talk about balancing, it's as if you're doing this, when the parent's rights have to be considered much more than the third-party right.
And that's a wonderful point, Judge Howe. When I'm using balancing, I'm talking about balancing best interest, minimally intrusive, the special weight that's put on mom, and her decision here. That's really the balancing, not the balancing of, hey, parenting days and this. And kind of balancing when I reference to a parenting schedule, I know we're talking about parenting, is looking at a circumstance, how do we balance based on work schedules and those type of things. But again, going to the special weight and mom, she has the right to determine when she's going to allow time for her grandson to spend time with grandma.
Evidently not, though,
Well-
because she doesn't want anything.
Well, right, and that's where we're balancing this best interest and what's in the best interest of the child, minimally intrusive, and what mom's wishes and desires are, and we're not taking weekend parenting time away from her. And that's why I kind of referenced in my response was, mom has shown nothing here to suggest that this parenting schedule is intrusive upon her as a parent. Because she can't, at least when it comes to her work schedule. She wouldn't have
Isn't it
seen the child.
definitionally intrusive to say this child is my child to whom I have, again, I have to keep coming back to it, fundamental constitutional parenting rights, is removed from my physical control and outside of legal decision-making decisions, outside of my decision-making control for a percentage of the year against my wishes. I mean, is it really fair to say?
Well, it is, and I think you had mentioned that, or mentioned earlier, that really any time to a third party, whether it be grandparents, aunt, uncle, whoever it is, that is going to be intrusive. But you just mentioned decision-making authority. Again, I think I put in my response is, the judge in this case gave grandma zero rights, which the judge was correct in doing because it wasn't requested part, gave her no rights to make decisions. So if this child, for example, is
I guess
at school,
my point was that legal decision-making is as to certain types of decisions, sort of higher-level, ongoing, bigger decisions. But in terms of what TV the child gets to watch at night, in terms of what sort of religious overlay there is in the home as to what time to go to bed, all of those kinds of decisions are outside of mother's control when the child is with a third party. Isn't that true?
that is true. And if we look at this case, and I would dispute a little bit what opposing counsel said in regards to why mom had stopped the parenting or the visitation, is, and I think the court even noted in the ruling, that one of the issues came up is there was some domestic violence in mother's home. Mother has been, and this is on page 5, mother has been involved with a number of domestic violence occurrences and incident reports. That's when grandma brought this up to her, is, hey, I have concern about my son. One, there's never been, and the judge also ordered counseling. Mom had never done anything in regards to grief counseling for this child who lost his dad and was in the vehicle at the time. 2, there's domestic violence in mother's home. So mother expresses a concern here, then grandmother expresses a concern. Mother then, what does she do? She makes a false accusation and gets an order of protection that gets dismissed, and then she says, fine, you just can't have time, even though for
Where does the court
years.
get the authority to order counseling? Is that in 409?
I would agree on that, Judge, that they don't, the trial court did not have authority to do that. But that's not why we're here today. But I would agree with you, that's outside the statutory authority of the court to do
Might
that.
that be a reflection of how little respect the Superior Court judge had for this particular parent's rights? If
I
it
don't,
orders counseling when it doesn't have the statutory authority to do so?
I don't believe, I think it was judge's concern for this child who saw that there was a need and exceeded maybe what her statutory
Child's
authority
at
is.
school, child gets sick, school calls, if it's, within the time frame when grandmother has visitation, the school calls grandmother or school calls parent?
School calls parent.
And parent can pick child up?
That's, if there's an issue would pick the child up. If there's a educational decision or disciplinary issue, any of that stuff, that grandma has no legal decision-making authority here, no rights to that, and nowhere in the order does the judge say,
Does picking up a sick child, does that involve legal decision-making authority?
take him out of school, possibly would.
How about chaperoning a field trip?
Probably not, because that would be more of on the school's purview, not necessarily on a parent would be on there. But I think the past history here of grandma's significant relationship with this child over the years and the amount of time that mother had allowed.
What do we do with mother's testimony that she did that under duress? I mean, should that weigh into the court's evaluation of that factor, that yes, this was the history, but this history is, at least arguably in terms of testimony provided to the court, tinged because that was nonetheless against the fit parent's desire, even previous?
I think, one, if we're looking at, that testimony is the trial judge was in the position to weigh credibility. So that's one issue. I'm not saying that's the only issue. The second issue is here, I think, and I've been reading the transcript last night, if I remember that section, it said, because grandma said, if you don't, I'm going to have to go to court and try to get a court order. So is that really under duress of, hey, if you don't allow me to have time with my grandson that I've had over all these years, I'm going to have to go to court?
Another way to hear that is, if you don't allow it, I'm going to take it by force. I will cause you to incur legal fees and be subject to the jurisdiction of a judge over your right to parent your child. I mean, there's a couple of different ways to see that.
Well, there is, and I think, well, I won't even make that statement. I think there's some case law about whether threatening somebody with legal action, in at least an order of protection frame, is really threatening and intimidating, and it's not, because what other remedy does grandma have at that point? She's not threatening her physically. She's just saying, hey, if I don't get this, this is my only other option, because that is, under the law, that is her only other option here with that. So those are wonderful questions. Any other questions I can
How much does your
answer?
argument turn on the fact that this is grandmother versus some other relationship? Because 409 allows third-party visitation to more than just grandparents, right?
It does.
So I'm concerned if we issue something saying that the trial court was fine doing this, future courts or superior courts may not pick up on that nuance, that this is grandmother, and may allow other third parties a third of the year.
I think because we know with third parties, there has to be that local parentis part of it for them to even bring an action. So that would be something they would have to show. But I think the court can easily distinguish this case in saying, look at the past history here. Yes, this was grandma, but this wasn't grandma that lived out of state and saw the child once or twice a year. This is grandma for the first 3 years who watched the child significantly, and even as the record reflects, why her...
Sorry, just a quick clarification. The in loco parentis requirement is not part of 409C. Isn't that the subsection we're under?
Correct.
I think we're under C1 with a deceased legal parent.
Yeah. I was referring to when Judge Catlett asked about somebody else, a third party coming in besides grandma.
Sure, and my point is that under subsection C1, that third party doesn't have to be somebody who is in loco parentis.
Local parentis. I guess I'll have to look at the statute. I had thought there was a portion there.
There is. It's under A1,
Okay.
and that's a different...
Maybe I'm just referencing those, but yeah. Well, thank you. I appreciate the time today and appreciate your consideration of this case.
Thank you.
Thank you.
Counsel?
I'd like to thank the judges for their questions. I think that probatively hit on the points I was trying to make, perhaps much better than I did. Look, the question we are dealing with here is essentially how do we determine what is minimally intrusive under the guidance? And unfortunately, that is sort of a nebulous term that has to be presented. As was asked, and I can't think of any other case, and neither could opposing counsel, of any other case where a third party was awarded the amount of time in this case. Now, this is not a legal axiom, but I would say an extraordinary ruling like this would require some extraordinary findings by the court, or at least to lay out the basis for which these findings were, and we don't have that in this case. We have simply a handwritten form that was given immediately after hearing without, I think, his due consideration. To correct some things, to rebut some of the things raised by opposing counsel, he insisted that that it was minimally intrusive because the court allows mother to decide around the holidays which day mother will have. I don't find that to be minimally intrusive because basically what the court order says is either Christmas Eve or Christmas Day, or the day after Christmas has to go to grandmother. That means mother is not going to be able to do any travel for Christmas, and she has to schedule around on all of these holidays. The order as it stands right now, the question was asked, well, what if the child was sick during mother's parenting time at school and mother could pick them up? Who would pick them up? And respondent's counsel answered, mother. That may be true. However, this is a binding order, which means mother could pick up the child from school because the school would call her, but mother would have an enforceable order. She would have to return the sick child to grandmother if grandmother insisted, because that is the ordered counsel. In this case, I believe prima facie just the sheer amount of time is not supported by the court's finding or the evidence. The court made no finding that mother was unfit in any way, and the court should defer. I agree that the court could, in given certain circumstances, find this valid, but they need to make sure they state that on the record. They need to lay out that argument for the court. That was not done in this case. It was ordered immediately after, and this essentially put mother in the place. I think the way in which this was presented essentially put mother at a constitutional disadvantage to essentially prove that that mother was not entitled to time, and I don't feel that the court gave proper weight to the presumption that her rights take precedence. Thank you.
Thank you, counsel. Thank you for your arguments this morning and your helpful briefing in this case. We will take the matter under advisement and have a decision out in due course.